This series of webinars aims to help you advise your clients around housing issues that may arise for them after the UK leaves the EU. This video will take you through some of the issues that may arise for British and Irish nationals who decide to return to Northern Ireland after living in the EU. If you still have questions after watching this, you can contact Housing Rights Helpline on 028 90 245 640. Over the next 10 minutes, we will look at the housing rights of returning citizens, habitual residence and how to evidence it, applying for social housing from abroad, the homelessness tests, home ownership abroad, and citizens who have never lived in Northern Ireland. For a number of reasons, Irish and British nationals who currently live in the EU may find it more difficult to continue living in these countries after the UK leaves the EU. People who return to Northern Ireland will still enjoy the rights of British or Irish citizens, but their housing rights and options could be impacted by the amount of time they spent abroad. In many cases, their rights will depend on whether or not the returning individual has habitual residence. Habitual residence means that you live somewhere as part of your regular routine. If a person is habitually resident in a country, it is accepted that they are not there on a short-term or temporary basis and that they have settled or intend to settle in that country. Habitual residence in Northern Ireland can be lost if a person moved outside of the common travel area. This is an area made up of the UK, the Republic of Ireland, the Channel Islands and the Isle of Man. Whether a person loses habitual residence or not will depend on why they left and how long they were away for. If, for example, a person spent a short period working abroad but still maintained links at home, they should keep their habitual residence and not have any problems when they return. In order to claim most benefits or to access social housing, a person has to pass a habitual residence test. The decision maker has to believe that the person who has applied has both a right to reside in Northern Ireland and is normally or habitually resident here. British and Irish nationals have an automatic right to reside. Their citizenship is enough to satisfy this test. British and Irish nationals will, however, have to show that they are habitually resident. Legislation doesn't specify exactly when someone becomes habitually resident. Case law says that a person could become habitually resident at any stage between 1 and 3 months after living in Northern Ireland. However, we know that sometimes decision makers say that a person can't be habitually resident until 3 months after they've moved back to Northern Ireland. This kind of decision should be challenged. This 3-month rule is set out in the Job Seekers Allowance regulations. In 2014, the government changed the rules for accessing Job Seekers Allowance. These changes stop people from claiming job seekers until they had lived in the common travel area for at least 3 months. The intention of these changes was to prevent people coming to the UK and immediately becoming entitled to claim benefits. But the changes also apply to British or Irish nationals who return to Northern Ireland after living abroad. This 3-month rule is only set out in Job Seekers Allowance regulations. There is no fixed time limit for other benefits like universal credit. If you have a client who has been told that they can't get universal credit, housing benefit or help with housing until 3 months after they've moved to Northern Ireland, you can contact Housing Rights for advice. Habitual residence refers to residency in the common travel area. So if an Irish or British person who has never previously lived in Northern Ireland moves here immediately after living in the Republic of Ireland, Great Britain or the Channel Islands, they will pass the habitual residency test. But any British or Irish person who moves to Northern Ireland after living outside the common travel area for a period of time will have to show that they are habitually resident. A person can apply for housing benefit or universal credit if they are habitually resident. You should advise clients who have recently returned to Northern Ireland after living abroad to gather evidence they will need to help to show that they are habitually resident. This can include proof that they have registered with the GP, evidence that they have a local bank or building society account, proof that they have a tenancy or permanent settled address, records which show that they are working or studying, evidence that any children in their household are enrolled in and attending a local school. There may be an increase in applications to the housing executive from Irish and British nationals currently living in Europe who wish to return to Northern Ireland. Many expats are concerned that Brexit will affect the cost of living abroad or that they may no longer be able to afford healthcare, and this could force them to return to the UK. A person can only apply for social housing if they have a local connection to Northern Ireland. The Housing Executive Selection Scheme Guidance Manual sets out the types of situations that can establish such a connection. The following scenarios should be sufficient to show a local connection and make someone eligible to submit an application from abroad. They are having adult family members living in Northern Ireland who have lived here for at least 5 years, having been brought up in Northern Ireland or having lived in Northern Ireland for a considerable period at some point in the past. If your client has returned to Northern Ireland and has nowhere to stay, ask the housing executive for help. There is no need to show that a person has a local connection to Northern Ireland if they are homeless. The housing executive must investigate their circumstances if it has reason to believe that your client is homeless or likely to become homeless in the next 28 days. The housing executive will have a legal responsibility to provide them with emergency housing if they appear to be homeless and vulnerable. As with everyone else, returning British and Irish nationals will have to pass the 4 homelessness tests in order to be entitled to help as a homeless person. There is a possibility that a person who still has a home abroad or who voluntarily left a home abroad may have problems passing the homeless test or the intentionality test. But if a person can show the housing executive that it wasn't reasonable for them to keep living in their home in the EU, they should pass these tests. If a person owns a home abroad, this could affect their ability to claim benefits and help pay their rent. The value of the property must be declared when they apply for benefits. The value of the property is the property's likely selling price minus the cost of any loans that are still owed on the property. The value of the property will reduce the amount of benefits a person can receive, and benefits will stop entirely if a person has savings or assets, including property abroad, valued at $16,000 or above. There are certain circumstances which allow the value of the property to be disregarded for fixed periods of time. Advisors at Housing Rights can go over these circumstances with you if you aren't sure of them. To recap, people who return to Northern Ireland may find their housing rights and options impacted by the amount of time they spent abroad. They will need to prove they are habitually resident in Northern Ireland. If applying from abroad, they will need to prove a local connection to Northern Ireland. They will need to prove it wasn't reasonable for them to continue living in the EU. Their benefits may be impacted if they still own property abroad. If you are trying to help a client and are being told they cannot apply for housing or homelessness help, you can contact Housing Rights for advice on 028 90 245 640. Visit housingrights.org.uk to keep informed of issues surrounding Brexit and housing. You will find news articles, our professional resource, The Housing Rights of Migrants Living in Northern Ireland After Brexit, and our series of webinars covering the housing issues that may arise once the UK leaves the EU. Signpost your clients to our public advice website, housingadviceni.org, where there is information specific to an EU national's housing rights after Brexit in 8 European languages, including English. If you would be interested in Housing Rights running an information session for your clients, get in touch. The information presented here is correct as of January 2020. However, there is still some uncertainty around the issues of immigration status. Follow us on Twitter or Facebook, or check back regularly to housingadviceni.org to make sure you are up to date on the issues that Brexit may have on your client and their housing situation.